Could I just make one very quick factual point that I was instructed on over lunch? I said none of them had been promoted in the 15 years that have elapsed. In fact, it took 12 years. One of them, Mr. Cowley, I think the second claimant, did finally make it to become a police sergeant, did his exams, but only after 12 years. So that's just that's the corrected version of their success in terms of climbing up the ranks.
Well, if we were to regard that as relevant, we would need far more information.
I just thought I'd better put the record straight.
But it's good of you to put the record straight. Thank you very much indeed. Mrs. Staff.
My Lord Mance referred yesterday to Metcalfe and Medal and asked that we get copies of it, and we have them here. If I could just hand those up. It's 2002 UK House HL 27, reported in the first volume of the appeal cases 2003.
Thank you.
Thank you.
In fact, I see my Lord Wilson was the first was involved in the case in the Court of Appeal.
It's my big moment, Mr. Warnock.
Yes, where you spoke truth to power.
Lots of it.
It's a rather different case in terms of its background, in that it was a claim, obviously, for wasted costs against barristers, and hence the case has the additional feature not present here, that the privilege belonged not to the people who were on the receiving end of the wasted costs application, but the privilege belonged to the clients who had declined to waive it for the purposes of the wasted costs application. However, there are some useful points to be drawn from the case. One is at page 135 from the speech of Lord Bingham, and at between letter E and F, he refers to a point which he said was well put by Mr. George Lawrence, QC, sitting as a Deputy High Court Judge in Drums and Packaging. And he says, as it happens, privilege having been waived, the whole story has been told. I cannot help wondering whether I'd have arrived at the same conclusion had privilege not been waived. It would not have been particularly easy in that event to make the necessary full allowance for the firm's inability to tell the whole story. The point I just make there is it illustrates the dangers of speculating in the absence of privilege being waived as to what the true facts were, and may illustrate the difficulties an employer might have should they, for good reason, choose not to waive privilege in a case, and people seek to draw inferences from that. The second point of assistance from the case is it reaffirms the importance of the doctrine of absolute privilege. And at paragraph 24, Lord Bingham said it was not submitted to the House that a relaxation of the existing rules on legal professional privilege could or should be permitted in a case such as the present. And he refers then to the decision of the Queen versus Derby Magistrates Court, ex parte B, which gave no encouragement to such a submission. And indeed, we've referred to that case in our written case about the importance of absolute privilege. And a similar point, albeit he refers to the fact there's been some academic criticism of the absolute nature of privilege, was made by Lord Steyn at paragraph 30. And at paragraph 60, Lord Hobhouse also recognised the strength of a claim to privilege, saying, as absolutely observed, as already observed by my noble and learned friend Lord Steyn, the nature and the extent of legal professional privilege has not been in question on this appeal, nor has it been subject of any argument. Its absolute and paramount nature has been accepted by the respondent, citing Derby Magistrates Court ex parte B, again, and General Mediterranean Holdings SA v Patel. He then goes on to say that there are certain circumstances when privilege is overridden related to a lawyer's duty to the court. But of course, none of those would have any relevance in the sort of context we're talking about here.
Do speak up.
None of those would have any relevance.
It's one thing to let your voice drop when you're reading stuff that we're all reading.
Yes.
Quite another thing when you're making your own
I
observations.
shall throw my voice a little further. The point he makes about there are certain circumstances where the privilege may be overridden by an advocate's duty to the court clearly doesn't apply in the facts that this court is concerned with, or the situation we're concerned with here. That's all I wanted to say in relation to Metcalfe and Mardell, unless there was another point anybody wanted me to address on it. But turning to the subject of privilege, in another aspect, reference was made to the Barker case, and can I just draw attention to the passages which we submit to make clear the circumstances in which the common interest privilege was said to arise there. The Barker case is in volume 3, tab 23, it's MS 1031. Sorry, that's the wrong one, that's Mander. It's MS, it's tab 22 of volume 3, MS 1013. And at MS 29, which is in the separate judgment that was produced in that case relating to the disclosure application, because the first judgment dealt with some of the substantive issues. Picking up the story at 1028, the bottom of the right-hand column, Lord Justice Stevenson said, "Now the short point raised here, which the learned judge thought or apparently thought raised issues of fundamental importance, is this: have the plaintiffs got such an interest in the proceedings to which the documents relate, and of which production is objected to by the defendants on the grounds of confidentiality or legal or professional privilege, that they should be just as much entitled to see them as the defendants themselves? In the ordinary way, of course, a third party cannot possibly claim to have disclosed to him in an action against a second party documents which are relevant to the second party's claim against someone else, a first party, or to a defence to a claim brought against him by that first party." And I do place particular reliance on that remark. But if the so-called third party is not a total stranger, but is a person who has a joint or common interest with the defendants whom he has sued in claims which they have made or which have been made against them in other proceedings, then he is not a stranger to these proceedings. And if his interest is sufficient, I would have thought it must follow in fairness and common sense, unless there is some authority against it, that he would be entitled to see those documents, and the plaintiffs in this case would be in the same position as the defendants as regards their right to have disclosed to them counsel's opinion, pleadings, and so on, all relating to the claim or claims in which they had this shared interest. And then importantly, he says that they have a shared interest, counsel submits, and it arises out of the purchase agreement, which they came to on the 9th of November 1972. And if this matter were res integra, I would read again section 1015 of the purchase agreement, but I find it unnecessary to read that again because it clearly shows that they have an interest. And indeed, I would have thought it clearly shows that the Armco claims were being made and pleaded in paragraph 11 of the points of claim, which I have read, by the defendants acting on behalf of themselves and the plaintiffs jointly. That section shows that the defendants and the plaintiffs had got to go, to assist in various ways in the prosecution of those claims, and that the plaintiffs may be liable to pay the bill. So quite far removed from the sort of interest that's been put forward here. And just in passing, my Lord Kerr referred to the fact that the judge in paragraph 60 at MS 131 had rejected the voluntary assumption of responsibility argument and pointed out that the respondents did not have a sufficient interest in the proceedings. And I think it was said by Mr. Bowen, well, this was all a strikeout application. I would just remind the court, in fact, it was a summary judgment application as well. The judge did consider witness statements, one put forward by the respondent, one put forward by the appellant, and indeed he gave summary judgment on the part of the claim related to assumption of responsibility.
So your point is he was making a finding on evidence?
Yes.
Mm-hmm. Well, I think it was my Lord Manch who really made the point that despite the different context, the findings are relevant to the argument that you want to employ.
Turning to another point, a different subject. The case of Singh, which, as I said yesterday, we submit is not inconsistent with our appeal, and we don't have to go so far as to say it's wrongly decided. However, I had one of those thoughts that occur and dawnings that sometimes happens at 4 o'clock in the morning.
Light bulb moment.
Yes. And in fact, Singh is very difficult to reconcile, indeed impossible to reconcile, with the manifest shipping case. Well, maybe impossible is putting it too highly. But the manifest shipping, of course, the case my Lord Mance drew attention to yesterday, in the contract of utmost good faith, which applied in the insurance contract, we looked at the passage in paragraphs 75 and 76 of Lord Hobhouse's speech, where he said that the issue of the writ changes everything, and drew to an end the obligations under the contract and brought into play the obligations which arise simply under the civil procedure rules. Now, it is right, he said, that there are certain circumstances where substantive rights can be dealt with in pleadings, such as accepting a repudiation of a contract was one example I think he gave, and another was in relation to landlord and tenant proceedings. But the fundamental point is good, that the litigation, contrary to what the Court of Appeal thought in a point which they acknowledged was not argued in any depth before them, does actually have the impact of bringing to an end, we would submit, the any role, if there was a role in the first place, for the implied term. Manifest shipping was not cited in Singh. It's not referred to in the judgments, and it's not referred to as one of the cases drawn to the court's attention in the argument, no doubt for that reason, that it came up as a late point. It wasn't well argued. Can I turn to the case of Gogay? Because my learned friend sought to draw out of that an argument that you could have duties in conflicting, with where there are conflicting interests. Could I invite the court, please, to turn to MS 1214, and it's volume 3, I think. Yes, volume 3, tab 31. MS 1214. The point which is to be made about Gogay, before I go to the passages, is that there were two different processes involved. One was the process under what was loosely called Section 47 of the Children Act of investigating the child's complaint, or whether the child was at risk of actual harm, and a second separate process which related to the bringing of disciplinary proceedings or the suspension. And my lady said at paragraph 38 that it's clear that there is a distinction to be drawn between the process of investigating whether a child is at risk of significant harm and the process of dealing with a member of staff who may be implicated in that risk. It is a gross oversimplification to conclude that because some form of investigation is taking place in relation to the child, the employee must inevitably be suspended. There are at least two reasons for saying this, and it's the second reason I particularly draw on at paragraph 40. Secondly, the issues are different. The child protection issue is whether or not the child is suffering or is likely to suffer significant harm, and whether or not the local authority should take any action to safeguard or promote that child's welfare. There may have been something amounting to an allegation against a particular individual, but very frequently there is not. There may not even be a suspicion about a particular individual as opposed to any one of a number of people with whom the child has been in contact. The staff issue is whether it's appropriate in the interests of either of this child or the staff member or the investigation to separate the staff member from his or her usual place of work. If that is appropriate, as often it will be, the next issue is how should that be done? And what we say is, in this case, we're not concerned with two separate processes, but we're concerned with one process, which is the defence of the litigation. Gogé would have more purchase if my learned friend was saying that the litigation had been used in some inappropriate way in disciplinary procedures which were a separate process. And secondly, in relation to the issue of conflict, we do draw on and rely on the paradox identified by my Lord Wilson, which is that the paradox is that to establish whether or not there was a conflict, and to prove that there was one, the employer has to, if the respondents are right, waive privilege and disclose material that, in fact, the respondents have no right to see. My Lord Kerr asked, might there be a difference in approach insofar as the implied term had any purchase between incidental impacts on employees as against targeted action against employees. And we submit that there may be something in that it reflects the dictum, the rather colourful dictum. It's back to Oliver Wendell Holmes Jr.'s dog again, about the difference between recognising whether one's been kicked or simply stumbled over. And
oh, that's the difference between negligence and intentional harm, isn't it?
Yes, and it may well be that in a case where the harm is purely incidental.
But my Lord was drawing to your attention, I think, the same point that my Lord Wilson had made earlier, unless I've misunderstood them, which is there may be a distinction between action taken directly by an employer against an employee and action taken by an employer in a different context altogether in relation to a third party, which has incidental effects on the employee. That was the...
Yes, I think that's right. I mean, the query that I have, and it's a genuine query rather than indicative of a settled view, is whether in the different context where an incidental effect of action taken by, for instance, in this case, the Commissioner, is to have an impact on the police officers. They're not the primary target of the action, but they are affected. That's the argument anyway. Whether a different approach to the question of whether that meets the criteria for breach of the duty of trust and confidence is warranted then from the situation where the employer deliberately targets the individual concerned. It seems to me that there's at least a discussion to be had as to whether or not a different approach is required.
Certainly the authorities, as we sought to distinguish the authorities relied upon by the respondents, would be consistent with such a distinction, because the Yap and the Gogay and the Dead Man cases all involve the employer taking action targeted at the employee. If one looks at the other postulated category of distinction, the Malik might fit into that, but there, of course, the touchstone was that the employer had acted dishonestly. The employer, it was the employee was not the directly targeted victim of thoroughly dishonest conduct by the employer, and that may be where the distinction lies, that in the incidental cases, one is looking at bad faith or dishonesty.
Well, presumably your argument is that without the dimension of that extra ingredient of dishonesty on the part of the employer, that a clear distinction between the two contexts should be drawn.
Yes. Finally, my learned, well, not quite finally, but my learned friend relied on the ABC case, which is at MS 893, which is volume 2, I think. It begins, in fact, at MS 888, but it's MS 893 that I want to go to. It's volume 2, tab 18. I don't know if this decision is coming here, but I'll deal with the Court of Appeal's decision as it stands. And an important point to note is that at paragraph 19, the claimant was relying on guidance given by the Royal College of Physicians and the Royal College of Pathologists and the British Society of Human Genetics. And a central passage said that the rule of confidentiality, the Human Genetics Commission, the Nuffield Council on Bioethics, and the GMC have all expressed the view that the rule of that is of patient confidentiality is not absolute. And that was a factor that weighed heavily with Lord Justice Irwin, was the fact that because the doctor's professional obligations involved them having to make decisions on occasions to form relatives, the normal rule that a doctor didn't owe a duty of care to anyone other than his own patient had less purchase. And we see at also at page 895, this starts really at the bottom of 894. Here the defendant suggests there's no public interest to counterbalance the obvious public interest accepted by all in preserving confidence in the doctor-patient relationship. I find this argument difficult to follow. The public interest in the preservation of the doctor-patient relationship must inhere in public confidence in the way doctors approach their obligations to patients. For myself, I find it difficult to see how public confidence is necessarily improved if private law action is available to enforce only some of the professional obligations laid down in the relevant professional guidance, whereas here the professional guidance enjoins a clinician to consider breaching patient confidentiality if the circumstances demand it. I do not see that it's necessarily the case that public confidence is increased because the patient could sue, but the person who needs the relevant information could not. And if and when a decision to override patient confidentiality is taken in line with relevant professional guidance, it seems to me then arguable that public confidence will be diminished rather than enhanced by the absence of the duty. So that was an important feature of that case. And another feature he placed reliance on as an exception in some ways proving the existence of the general rule was at paragraphs 33 to 44 on MS 899. His lordship seemed to think paragraph 43, having referred to, he said there's an important distinction between the situation of a geneticist and all the other examples given. However problematic and whatever the implication for third parties, the clinician usually only has the knowledge of medical facts about the existing patient. It is only in the field of genetics that the clinician acquires definite, reliable and critical medical information about a third party, often meaning that the third party should become a patient. And although parallel duties and difficulties of disclosure arise in other areas of clinical practice, usually to do with risks posed to others by the condition of the existing patient, the clinical geneticist is in a different position. So it's a rather confined decision.
Well, yes, but the basic decision here was that the doctors owed a duty to the pregnant daughter and to the father.
Yes.
So you're not going to be able to win this appeal on the basis that if there's any conflict between the first duty and the second duty can't arise, Mr. Warnock. You've really got to establish, haven't you, that the postulated duty here would be unworkable.
Yes.
Do you agree with that?
Well, I don't fully, because I do say that there is a general recognition, even in this case, of the fact that the general common law principle is that the law won't impose duties where interests conflict. And what His Lordship, Lord Justice Irwin, was doing here was drawing a very limited exception to that based on the professional guidance in this case.
Isn't there a distinction between the present case also, where you could say that the argument is that there should be concurrent duties, which will continue to conflict, and A, B, and C, or ABC, where actually the argument is, as I see it, that one duty overrides the other and becomes the duty. So there's one duty, but it just switches at a certain point from a duty to keep confidential to a duty to disclose to a third party.
Yes.
Otherwise, there aren't concurrent duties about the information. You couldn't have concurrent duties to keep confidential and to disclose at the same time. It ceases to be confidential. It's now a duty to disclose. So it's a different situation from one where it's argued that you're conducting a business, you've got to conduct it with two diverging interests in mind, because then you're inextricably caught.
Yes, I respectfully agree with that analysis.
It's a question of the duty to disclose really overriding the duty to remain confidential. And presumably you would say this analysis is geared to the particular circumstances of that case, where obviously there is a duty to keep confidential information received by you as a clinician in the course of treating a patient. But when some supervening circumstance, such as the possibility of someone being affected genetically by the condition, the need for that person to be informed will override, as I say, the primary duty.
Yes, it takes the place of the primary duty.
Does it inevitably follow that because your duty to your patient or the patient has been overridden by other reasons why it's important to disclose, does it inevitably follow from that if you don't do it, you are liable to the person to whom you have not disclosed? I'm not sure that they entirely follow.
I don't think so, because obviously there has to be a trial of all of these issues. I mean, this was just a strikeout application, wasn't it?
It was, yes.
I mean, there may well be very major considerations that will be deployed on either side of the argument, I should think.
Yes.
But I was thinking particularly, I mean, a well-recognised exception to medical confidentiality is where a risk of child abuse is detected. But I'm not aware of a case where a child has sued the doctor who failed to disclose what they should have disclosed, or indeed a social worker who failed to disclose. I'm not aware of one. There may be one. So that's why I'm raising the question. They don't necessarily go hand in hand.
No, they don't. No. I mean, there are all sorts of evaluative exercises to be undertaken in the trial of a case like this. all that I think Lord Justice Erwin was saying is that in the particular circumstances of this case, there is a tribal issue. It may well be that some sort of assessment has to be made about the risks of incidence of Huntington's disease, and the question of relaying information to a vulnerable patient or someone who might be at minimal risk and so on. So one can easily foresee either outcome on the ultimate trial.
Yes. The final point I wanted to come to is my learned friend floated the possibility that there may be remedies available under the Data Protection Act and under what he called the emerging tort of misuse of private information. Well, what we say to that is, if there are alternative remedies potentially available, then there's no need to distort the law of negligence to fit fit this case. And of course, we also reiterate what we said yesterday when it was said, well, the employees or the officers might have struggled to get a job somewhere else or something. Of course, the employer has to comply with its spring duty if it gives any reference. And in assessing any application for promotion, has to act fairly in that context.
Have I got this right? It is not now suggested that settling the case in the terms that it was settled was a breach of duty.
It is not.
What is alleged is that the conduct of the litigation up to that point was so deficient as to be a breach of duty. So in a sense, I'm slightly bothering about the relevance of defamation, which of course is words which lower somebody in the estimation, blah, blah, blah. But I was still, the reason that I raised the question with Mr. Bowen is that reputational damage is not something that's normally actionable. We have reputational damage all the time. You know, when people justly or unjustly criticise our judgments. Or, label us in particular ways, but we don't have a cause of action in respect of that. So that's why I was asking Mr. Bowen, when is there a cause of action for people who either intentionally or negligently cause you reputational damage?
Well, in fact, as my lady knows, the tort of defamation is obviously the principal remedy, and of course it comes with lots of qualifications. Not just the defences of qualified privilege and so forth, but also the fact that you can't defame someone who's dead, for instance, in a way that's actionable, something which has attracted a lot of comment in recent time in relation to the case of Bishop Bell. So my lady's right. It is the tort of defamation which is the primary guardian of reputational interests, and the circumstances in which reputation has been protected in other contexts have been very narrowly and strictly confined, the spring and guardian basis being one, and Malik the other. But I'm not aware of any other case or category of case outside the sort of dishonest conduct that occurred in Malik, or the voluntary assumption of responsibility undertaken in Spring, where the tort of negligence has undertaken the duty of protecting reputation. And we say, from the point of view of legal coherence, it is right not to extend the tort of negligence to cover the facts of this case, for that reason and the other reasons we've put forward. My lady, those are my submissions in reply, unless there's anything in particular the court wanted to ask me.
Yesterday afternoon, we got a bit bogged down in some of the facts.
Yes.
Mr. Warnock, we were looking, as you know, for the apology
Yes.
which you made in court.
Yes.
And you apologised for, quote, the gratuitous violence, unquote, of these claimants. We wanted to see that in context. We couldn't immediately locate it. You needn't go to it. Just give us the reference to where you apologised for gratuitous violence.
We don't, because, in fact, but for the fact this was a strikeout summary judgment application, there is an issue as to whether there was a public apology. For the purposes of the statement of facts and issues, we've accepted the allegation that there was one because the judge accepted it. It appears in Mr. Justice Jay's judgment.
So it's part of the assumed facts?
As part of the assumed facts. So Mr. Justice Jay proceeded on the basis that there was an apology, and if I can just
give us the paragraph number, please, Mr. Speaker.
Yes, it's, I think, yes, at paragraph 4, I think, on page 24.
Thank you.
It said that an apology was made for the gratuitous violence to which he had been subjected. So that's the genesis of that.
Very well. Thank you.
Sorry, page 24 of...
MS 116, I'm so sorry, MS 116, I've given the wrong page reference.
Yeah.
It's MS 116, paragraph 4,
Yeah.
and it's about 4 or 5 lines up from the bottom.
Yeah.
Yes, it's according to paragraph 82 of the particulars of claim. Oh, yes.
And
The preceding paragraph as well. All right.
I accept paragraph 82 of the particulars of claim isn't in quite those terms, but for the purposes of assumed facts, we've proceeded on the basis as the judge read it.
But basically, this was the basis on which the judge was
Yes.
deciding strikeout summary judgment,
Yes.
rather than any concluded question of fact,
Yes.
like everything else. Thank you. Well, thank you indeed for all the arguments, both written and oral. I feel sure there are plenty of people in the room who've contributed to the written arguments, in addition to those who've been on their feet. And you've set us quite a puzzle, which we will now go away and consider how we shall resolve. So, court is now adjourned.